Good afternoon, everyone, and welcome to today's Open to Export webinar covering the importance of having a clear set of international terms and conditions. My name is William Barnes-Graham, and I am the Senior Content Editor at the Institute of Export and International Trade. Open to Export is an online service helping small businesses get ready to sell overseas through our step-by-step articles and guides, regular webinars, our Export Action Plan tool, and our quarterly competitions. You can find out about all of these on our website at www.opentoexport.com. Open to Export is powered by the Institute of Export and International Trade, the UK's professional membership body for traders, endorsed by the World Trade Organization and the International Chamber of Commerce as a small business champion. We offer a unique range of individual and business membership benefits, education and training catering for beginners through to master's degrees, and an always exciting and prestigious program of events celebrating UK businesses' exporting achievements. We will be running a live Q&A at the end of the session, and you can ask questions at any point during this webinar using the question box on the control panel to the right-hand side of your screen. We have two fantastic regulars on the panel today. Presenting on the Institute's new international T&C templates will be Leslie Batchelor, our Director General. But before that, we've got Liz Ward from Virtuoso Legal, who will be explaining why it's so important that exporters have proper terms and conditions when trading internationally. Over to you, Liz.
Thanks, Will, and welcome to everybody this afternoon. I've put on here terms and conditions, the key to unlocking international trade, because I think it's important for you to understand terms and conditions are really vital in any business. But the key issue here is that with terms and conditions, when you're trading in the UK, we've got a fairly well set of established case law and systems and ways of doing things that you can fall back on, even if your terms and conditions aren't perfect, or even if they're non-existent at all, which I wouldn't recommend. But even if you don't have that, you've got a certain level of certainty. You know what you're dealing with, you know that both parties are in the United Kingdom. With international trade, terms and conditions become absolutely essential. And that's what I'm going to be talking over for the next few minutes, about how important it is to have a really good set of terms and conditions. And as with everything in business, what I would always urge you to do is to think thoroughly before you actually commit to paper or commit to international trade. Because as I say to many of my colleagues in the office, if you've got 6 hours to chop down the tree, spend the first 4 hours sharpening the knife, and getting a good set of terms and conditions falls into that category. It's all about preparation. It's all about making sure that you're dealing with the right people on the right terms. Next slide, please, Will. That's me, moving swiftly on. I don't think you need to see too much of that. Let's move on to the next slide, please, Will. Right, so international trade, it's really about establishing certainty, about establishing all the rules of the game, as it were. One of my former colleagues used to have this wonderful logo up on his wall, and it said, "Before you start the war, know the terms of engagement," which always made me laugh for a lawyer to have that in their office. But it's true in business as well. It's really important to establish the ground rules with which you're trading with somebody else. And the sort of unknown quantities that you're dealing with in an overseas market would be what the local legislation is, for example, what the relationships is between the parties. It may be that you're contracting with 2 or 3 different parties in an overseas market, and it's really important to define and set out precisely what your arrangement is. Is it going to be an agency agreement? Is it going to be a reseller agreement? Is it going to be some kind of international distribution agreement? Because all of those have a slightly different meaning to different people. So think through before you get into an overseas trade situation what sort of relationship it is you're going to have with somebody. Are they going to resell goods in the territory? To what extent are they going to do so? Are they merely going to take orders like an agent? So those are important. You need to think over as well things like, for example, any intermediaries that you're dealing with. Are you going through one person to get into another market? What's your relationship with that person? What responsibility are they going to take for payment terms, for example? And bear in mind this, the further away you are, the less you have in terms of direct influence on the market, and the less understanding you have sometimes of what that market entails and what that market demands. And things, for example, that you would think were fairly uniform aren't always that uniform. Take, for example, safety regulations. One of my clients provides and sells bicycle accessories, everything from kind of safety helmets to bicycle pumps and things like that. And certainly the local legislation for dealing with safety requirements for helmets on a bicycle is radically different in the States from what it is over here. And you wouldn't have thought that, but it is the case. And they have different standards even within the European Union, where we have fairly harmonised legislation. There are different standards for example, bicycle lights, for things like how the wheel is and how illuminated it is on a bicycle. So those are all sorts of things that you might want to think about before you even do any business overseas, and have a look at that. And needless to say, of course, when you're dealing with markets like, for example, the Far East, you need to know precisely what the local customs are within that environment, what people find socially acceptable. I've got another manufacturer who makes jams and marmalades and things like that. She sells quite a lot of her jams and marmalades to the Middle East. Her big sellers over here all have alcohol in, but clearly the ones that she is selling to that market out in the Middle East don't have alcohol in and have to be guaranteed to be alcohol free for that particular market. So establish the ground rules, make sure that you've got a definition there of the relationship and who's going to be responsible for what. And when I say that, I think what you've got to do is decide who's going to mark her goods as being safe, who's going to look into legislation, and put that there in your contract. Next slide, please. So this is where your terms and conditions come in. What you really need to do is to sort of sit down in your mind and work out on a piece of paper what your heads of terms would be. What is business critical to this arrangement? What are the important things and what are the nice things to have? It's not going to be the most interesting piece of work that you do, but it is quite a useful thinking tool to go through all the terms of trade. And the two things, as a word of warning as a solicitor, that I see people fall out again over time and time again are the two P's, payment and performance. So again, if you spend a little bit more time on payment and performance, it won't be time that's wasted. For example, who precisely is going to make sure that the goods are properly shipped? Who's going to collect them? How are they going to be paid for? Those kind of terms are really important for you to sort of think about up front. And with a set of terms and conditions, you get to decide what goes into that relationship with a third party. You get to decide then precisely who performs what. Maybe some negotiation there, but it's really important. Next slide. So it's about doing business your way. And don't be too shy about contracting under the laws of England and Wales, because we're a shipping nation. And for centuries, we've had big contracts that even have had parties who aren't resident in the UK would be contracted under the laws of England and Wales. And the classic ones are things like insurance contracts. So you can have some really big insurance contracts and shipping contracts where you can have 5 or 6 parties, none of whom are domiciled in the United Kingdom, but all of them will rely on established terms and conditions under the laws of England and Wales, not only to ship the goods and to insure the goods, but also in case of a dispute where there's a decision, where's the court decision, where are you going to fall out? And again, universally, the courts of the High Court in London is universally recognised around the world as being a very good and independent place to take any dispute to. So again, that's another good reason to set out the terms and conditions. Any dispute that you might have must be covered by the laws of England and Wales, for example. I would also caution you to away from using poorly drafted terms and conditions. I've been online and I know it's increasingly kind of prevalent for businesses, small businesses in particular, to buy templates off templates you can buy for sort of £100 or whatever online from some of these websites. Be very careful about them. I've looked at some of these and they really are one size doesn't fit anybody at all. The one thing that the Institute of Export have done here, I think, is to get a really good set of terms and conditions for you to use, and that's part of your membership as I understand it. But with that, at least you've got all the bases covered there for international trade, and you can get them bespoke upwards. But don't see it as being something trivial. If you've got an important contract, for goodness sake, make sure you get the contract drafted that you want and define the business going forward as you would like it to be. Next slide, please. Getting paid. Well, it's the one thing that I think, payment and performance, it's the one thing that people really get very worried about. And within a set of terms and conditions, you can set out precisely how you're going to get paid. Now, it could be that it's a really massive contract and there's going to be stage payments on taking the order, for example, stage payments on when the goods are shipped to somebody, and then a third payment when the goods are delivered. But do get that clear up front. And there are lots of different ways of getting paid. I mean, that's a seminar of its own. But for example, part payment up front does reduce the risk for manufacturers, and it does improve your kind of liquidity and your cash flow. And a lot of people nowadays we see are increasingly ask for at least 50% of an export payment up front with the balance payable on delivery. Some people take whole payment up front, and if you can do that, clearly you've mitigated your risk significantly. But again, that might be something that you get covered off in your terms and conditions. So say, for example, the goods don't arrive at their destination, or they arrive at their destination and there's some kind of dispute. Again, you can have something in your terms and conditions that deals with that particular scenario. I, a few years ago, had acted for a company who had bought from the Far East a number of beach accessories, shall I call them. I think they were like beach mats and this kind of thing. And part of their terms and conditions said that they would be exported to the UK, and before being wrapped, they were sterilised and they were put in plastic packaging ready for export. Unfortunately, the shipping process wasn't quite as straightforward as had been hoped, and the goods sat, I think, at Singapore for sort of 3 or 4 weeks in a warehouse there. And lo and behold, when they arrived in the UK, they had mould spots on them, which meant they weren't really fit for purpose. I think only 1 in 3 of them could be used. Now, again, a good set of terms and conditions allowed for that to that particular dispute about who was responsible and who took the insured risk, etc., to be settled far more quickly than it would have been had there not been a good set of terms and conditions there. So do make sure that your terms and conditions are correct. Make sure that your banking payments and everything are clear to whoever you're dealing with, and that there's going to be no issues in relation to exchange control or issues in relation to which country you're trading and what goods you're trading with. Next slide, please. Limiting the liability. Again, this is a really good thing to cover off in your terms and conditions, because you need to be sure of what happens if there is a negative outcome. Say, for example, there are issues, and this is something that I think is going to be a real live issue in the case of the B word. I don't even say it. For example, where spoilt goods arrive at a destination, or where, for example, A ships goods to B but hasn't done the paperwork correctly. What happens then? Who's going to pay for the storage as something is sat in a warehouse in Mumbai or Mombasa or wherever, or Singapore, because the goods haven't been properly exported? That's going to be something that a liability that you're really going to want to cover off. What happens if they're sat in storage and there's some kind of storage charges to pay, or there's a claim on the insurance because actually they're now 4 weeks late for a particular project and they were time critical? What's going to happen in terms of who pays, who insures them during that time? These are the sorts of things that you might want to look at limited liability for. And if you are going to have a fallout, then, as I've mentioned earlier on, make sure that you've got a certain jurisdiction like England and Wales, for example, for any disputes. Make sure that you don't get caught up in local courts. Even courts on our doorstep in Spain and Italy can take months, if not years, to resolve fairly straightforward disputes. And I would advise you to think very carefully about going down the route of being sued in Italy, or being sued, even worse, in the Middle East or the Far East or whatever. The terms and conditions may also cover things like alternative dispute resolution. So, for example, things like mediation or arbitration proceedings, where you can guarantee then that you're going to come together around the table and talk about it in a commercial way to resolve the dispute, rather than resort to lawyers. As I said, please avoid any kind of foreign courts if you can help it. Next slide, please. The battle of the forms. This is something that you learn at law school, the battle of the forms. And it's when one side says, oh, here's my standard terms and conditions. And the other side says, no, here's my standard terms and conditions. And you have an argument about whose terms and conditions you actually apply to the particular kind of shipping of goods and the sale of goods. The thing to remember is that if you've got a really good set of terms and conditions, yours is probably going to be preferred by your other party because it's comprehensive, because it covers all the bases. It's just not about winning. Business is never about winning. It's about coming to a satisfactory conclusion. And sometimes that means compromising things, but it's up to you to set the parameters of that and to make sure that you're not accidentally negotiating something on somebody else's terms of trade. I've seen this many times over the years where there's been a battle of the forms and so on, and it's, almost like a Mexican standoff. Who blinks first is the loser, as it were. But if you have some kind of general agreement that your terms cover everything that's required, they're mutually beneficial to both parties, then you shouldn't have too much difficulty persuading another company or organisation to deal on your terms. And it also shows, I think, again, and I know I'm aware of the audience being a lot of SMEs involved in this, it isn't always about winning, but it sometimes is showing that you are a force to be reckoned with. It's a bit like I get a lot of questions about non-disclosure arrangements or confidentiality agreements. And sometimes just putting that under somebody's nose to enter into negotiations with makes them realise that you're taking the law seriously and you're taking your goods and services very seriously. And again, it's the same with a good set of terms and conditions. It shows that you're ready. It shows that you are somebody that's ready to be dealt with in the international market, and that you know what you're doing. So it gives you leverage. It gives you negotiating position. It gives you kudos. Next slide, please. So just to summarise, terms and conditions are a business critical document. Do not ignore them. It can significantly reduce your exposure to being sued. It can significantly reduce your exposure to not getting paid, and it can significantly enhance your role within another party in terms of setting out rights and responsibilities and expectations between parties. I often get the thrown back at me by SMEs, but the value of these goods isn't very high. Well, it might not be, but if you multiply, say, an order here for 10,000, an order there for 10,000, an order somewhere else for 15,000, what you soon find is that you're engaged extensively in international trade. And although the value of the individual goods might not be high, it is worth protecting that business, certainly on a global level. My rule of thumb is that if any one order is going to be over £20,000, then you should get a proper, fully compliant set of terms and conditions on which to operate. Because I know from being a litigator that an ounce of prevention is better than a pound of cure. Losses when you've lost your reputation in a market, or you've spent hours of management time with people like myself, it's just not businesslike. It's just not commercial. You're far better thinking through it and doing it justice in the first place before you get caught up in some kind of maelstrom over what has or hasn't happened with a particular shipment or delivery of goods. Next slide, please. So if you haven't got a set of terms and conditions, it is the equivalent to doing business in a blindfold way. A solid set of terms and conditions, whilst you might have something bespoke up, will cost you, a few £1,000s. It will definitely save you money in the long run. And if you look at it as an investment over the next 5 to 10 years, then it will definitely pay for itself. And it will avoid all the kind of horrendous elephant traps that you hear people fall into. One thing that I do have to say today is the set of terms and conditions made available by the Institute of Export are incredibly good value. I think probably will talk you through that later. But in terms of the comprehensive nature of what the Institute of Export has got on offer, they are extremely comprehensive and certainly wouldn't take a great deal of amendment up to bespoke them to your particular scenario should you need that. Next slide, please. So those are my contact details. I know that will bring round this up later on in the questions and answers, but what I would like to say to you is that if you've got any questions about today, I'm conscious of the fact it's a whirlwind tour of a massive topic. Do feel free to drop me an email or let us know if you want to sort of 10-15 minute chat. No obligation. We're happy to chat all those things through with you and perhaps make sense of some of your bigger questions. So now I'd like to hand over to Leslie Batchelor, who I understand has been backwards and forwards all over London this morning because of the B word, and is now ready to take on all comers in her battle with making sure that Britain's a better place to export from. Leslie, over to you.
Thank you very much. I think what I've been doing is trying to clarify a few situations and a few understandings. I'm not sure whether we're teaching the press or whether they're actually confusing the issues. I'm not really sure about that, but the BBC are very keen to talk to the Institute about these things, so that's great. So as Liz talked about the terms and conditions that we've launched, we're really excited about them. We're very excited that we managed to get something that we saw as a problem that businesses were facing increasingly into the marketplace at a good time, and also to be useful to you, which is obviously what we try and do as the Institute. So we noticed an increasing number of people are acting without a contract, acting in good faith, which is admirable in some ways, but very naive, and actually leaving them very exposed without any agreement on payment terms. One of the things we were very keen to do was make sure that there were some clauses in our terms and conditions that talked about anti-bribery and anti-slavery laws for the sake of you, when you're trading, to actually, if you've made it clear that you don't pay bribes, you can just refer people back to those terms and conditions. And obviously we all anti-slavery, and it's a very good thing to have as a clause. The other thing that we noticed was the way that the terms and conditions are written in the UK for our businesses are very, what I think the Americans would call, litigious. It means that it goes straight to a dispute instead of actually going through a process of perhaps mediation or trying to find a way through. If you're actually in a situation where your customer, the only recourse you've got in your terms and conditions is to go straight to court, that's actually very confrontational. It doesn't help anybody, and what it does tend to do is leave you in a circumstance where you and that company may not be able to operate together any longer. So within our terms and conditions that we wrote with Liz and her company, the mediation and going straight through to arbitration if necessary. It gives you those options as tools in your box that actually will help you understand how to work together and get over some of these smaller issues instead of making them into huge disputes. Next slide, Will. Thanks. So the consequences, risky approach to take, Liz already covered that. The unnecessary litigation that we talked about, and the potential damage to business relationships. We can't emphasize this more strongly. You know, if you're doing business internationally, you've probably spent a lot of time finding those customers, and to lose them because you've gone into an unnecessary litigation is a depressing thought. We want people to actually have great experiences of trading internationally and look at more and more markets. We don't want them in a situation where they're actually damaging their business, and worse still, deciding not to do any more trade internationally. We don't want anybody to be disenchanted with the wonderful world of international trade. Next slide, please, Will. So the solution is that we're offering these terms and conditions. There are 4 different ones. I'll talk you through those in a moment. And it's to our business members. So a small business membership is £375, and within that, these terms and conditions, the template most suited to your business is included. And I do think that actually it gives you this wonderful legal framework that actually helps you understand what your obligations are. You make an offer, you have the terms and conditions of that offer that you've made. It's the basis for a contract. It makes life a lot easier, especially for smaller businesses. Next slide, please. So the templates we've agreed are necessary, cover 4 usage. And you can see here we've listed them. So that's distant consumer goods, services, and digital content terms and conditions. That's non-online as the way in which you do your business. But an online business and consumer goods services, terms and conditions for the supply of goods, and terms and conditions for the supply of services. We spent quite a lot of time working out how these would work and whether we'd actually got all the different connotations covered, and I think we feel that this covers everything. Of course, if you are working in a very specific area, as Liz says, do talk to us and we get this sorted out, and we can advise you on which is the best for you, or if we really think you need it, to actually go ahead and perhaps tailor them specifically to your business needs. Next slide, please, Will. So the packages for a small business member, as I said, £375. You get access to our technical helpline. This is a huge, huge benefit to smaller businesses, and especially with something big that's happening at the end of March coming up. We need answers. We will help you supply those answers as often as possible. We're part of the Joint Advisory Consultative Committee for Customs. We're actually, we're actually working with HMRC to produce training that you will have seen on your emails and notifications. If you're not a member, talk to us and have a look to see about that, because actually the HMRC training also has attached to it some grants so that you can get discounts on that. And it's really about beginning to start to understand how you can learn more and really save your business money by actually understanding exactly how this works. So the training discounts are proportionate to your membership. The professional recognition, you're allowed as a business member to use our logo. We have a business membership logo. There's a full communication package. There's our wonderful World Trade Matters journal we're very, very proud of. And we've now started launching for members only what we call Talking World Trade Matters, and that's a webinar where you get a chance to, again, to ask lots of questions once a month and also to interact with other members, and we are slowly introducing more and more of the different members and their skills to each other. We have a lot of online resources. You know, if you can imagine, we've got qualifications that go from a level 1 through to a level 5, which is a second year of a degree in all the 4 pillars of our learning, which is world trade issues, tariffs, trade agreements, and unions, going through to the legal aspects of a contract, the intellectual property as one pillar. The second pillar is all about market research and marketing in a different culture. The third pillar is all about finance of international trade, getting paid, how we're going to actually manage currency risks and pricing. And the fourth pillar is all about compliance and regulation and the logistics of international trade. Those 4 pillars are studied and give us huge amount of content. We also have obviously the Open to Export website that's designed specifically for businesses that are just planning to set out or just finding out about it. So moving on, we've also got a jobs board, which is very active at the moment. You'll find anybody with any sort of qualification in international trade or experience is finding that they're being offered substantially more money nowadays. And we also have a new exporter package, which is where we will help you do an action plan and complete some market research, or help you complete some market research. It's a very full package, and it's very much designed to help small businesses get out there and embrace exporting across the whole world. Because world trade matters. That's really nice, isn't it? William, can you move on to the next slide, please? So we are actually working with DIT. This, they've realised, is very much part of their export strategy that they launched last year. And John Mahon, the Director General for Exports of the Department for International Trade, said, a crucial part of exporting is having the legal frameworks in place that allow businesses to trade confidently. I'm delighted that the Institute of Export and International Trade has launched these templates as part of the package of solutions on offer to help businesses export. I urge all UK companies that are currently selling overseas without proper contracts in place to take a look at these templates and implement the right one for them. Through our export strategy, the Department of International Trade has set out an offer for all businesses to ensure that they are able to make the most of global opportunities this presents. So we're really proud to be working with John. He's a really breath of fresh air, and he and Baroness Fair have been very supportive of the work that we've been doing here. Next slide, please. So the next step. Get involved, join us. If you're not already a member, talk to us. If you are a member, talk to us about the terms and conditions. We'll make sure that we can get something out to you. It's exciting times. It's very confusing, but I have to tell you that there's a lot of help from the Institute, from companies like Virtuoso Legal. There's a lot of help out there. Please don't think you're on your own, because we're all as confused as the rest of you. But we are asking questions, we are asking for answers, and I believe that they are beginning to come through. So just talk to us. I'm handing back to you, Will. Thanks.
Thank you, Leslie, and Liz as well. Some really great advice there, and hopefully everyone will see how beneficial those templates are for your exporters. And as Liz mentioned, we will circulate a link to Liz's contacts or kind of Virtuoso Legal in general for some of that further support. We're now going to open the floor for questions, and you can ask any questions using the control panel on the right hand side of your screen. The first question I'm going to put to Liz, then Leslie, is we had a couple of people in advance of the webinar ask about how T&Cs for services and especially what kind of things, terms and conditions or contracts would include for a service business. Liz, do you want to start on that and then I'll throw back to Leslie?
Sorry, just repeat the question. I didn't quite hear that.
So it's for service businesses.
Yes.
And the question was, what should a contract or terms and conditions include for a service exporter? What sort of things should it be covering?
Well, again, the key ones are the ones that I've mentioned before about who the parties are. One thing that people often get wrong with all contracts is certainty of who they're dealing with. I've seen quite a number of contracts where it has said, you know, Jim Blogs, rather than actually ABC Limited, for example, dealing with the right entities there, or in what capacity Joe Blogs is involved in a contract. So be certain who you're dealing with in any kind of an online contract. For example, define who your customer is. That can sometimes not be quite as clear as you might think it would be. In terms of online, there are things to consider like the distance selling directive, which will be, even though we have Brexit, that will be part of our national legislation, and so it will still apply. And there are rules around how you deal with taking payments, for example, what refunds people are invited are eligible to get, and so on and so forth. It would be useful to kind of answer this question perhaps by saying that it depends what you're selling online, because there are so many different services that are sold online. Everything from education and educational services through to coaching, through to all sorts of things. And they have very different requirements really as to what you'd put in a set of terms and conditions. Does that help? It's such a broad question. I'm not sure if I've hit the nail on the head.
Big question, isn't it? It's not really as straightforward as that, because it depends which service that you're talking about and how you're delivering it. So perhaps that's the sort of question that, if you've got the names of the people, we'll go back to them and give them a more detailed response for their own industry.
Yes, absolutely. If you do have any kind of specific questions, kind of sector specific, then it'd be good to follow up afterwards. One question for you, Leslie. Does membership of the IUE, what sort of resources does it give access to? Stella asked if it gives you access to things like Kronos. Kind of what sort of resources does it give you access to?
Well, we no longer work with Kronos, but we actually provide our own relationship with actually the type of documentation issues that they were fulfilling. We also have our doing business guides that we write. So we have a regular update of these things that we work with directly with a large organisation called Amber Road, who actually do things across the whole world. So we're tapped into a larger organisation than Krona now. So you get all of that with your membership. As far as the rest of the resources are concerned, you get access to all our experts. We have, specialists in AEO. We have specialists in WTO. We are very fortunate that we have a huge resource to draw from as far as people are concerned. We do have Open to Export, which is full of information. You don't have to be a member to use that, but we do have also, if you've got a specific query about something, we can actually point you to materials that we have online as well, which would only be for members, not for non-members.
Thank you. This one's for Liz, and it'll be recovering a bit of old ground, but it's probably worth recovering. It's from Jean, and Jean asks, kind of, what should a contract with a prospective agent include?
Well, agency agreements are where you employ somebody in a locality to take orders on your behalf. So they don't supply those orders directly. They pass the order on to the principal, and the principal then delivers, and the agent takes a percentage normally of the goods that are sold. It is very important with an agency agreement, in my view, to have performance levels in there. because one thing I've observed is that you sometimes get an agent who puts a lot of effort into a product when it's new, and then as the years go by, they get less and less interested in it, and they start to take other people's products on and promote those more heavily. And it might be that after a few years you want to get rid of somebody who's underperforming. So believe it or not, some of the most important provisions within an agency agreement are the termination provisions. You know, what triggers underperformance, and how much notice you have to give to pay somebody off. There are European regulations too, which it's important to be aware of, and they cover if in the absence of proper termination provisions, there are some rather draconian provisions that are imposed on the principal in particular to carry on paying agency fees for a long time after the contract's effectively finished. So I would say look at things like territory, look at things like performance, look at things like what will happen in a few years' time, how often it will be reviewed, what obligations you have to take on orders that the agent has brought to your door. There may be some instances, for example, with an agency arrangement where you don't actually want to do business with one particular entity. So you might want the right to not do business, to not take that contract on. And your agent's going to be a bit jumping up and down going, well, I've lost out on my commission here because you've not taken the order. So those are the kinds of terms that I would be considering for an agency agreement. The way that we normally work with people is we provide a kind of a set of heads of terms, we provide those, and then we talk through that with you before you start putting it out there to your agents to contract on. And again, as Leslie said, this is such an enormous topic. There's so many different types of ways of doing business out there, and so many different individual circumstances that it is difficult to be template about this. But those are the things that I would consider.
Thank you, Liz. Just
I think.
That's me.
I'm sorry. I was just going to say there's just a few things about agents that people do need to understand, that they do tell you everybody they've ever spoken to in their entire lives, and it is really important to try and set up a way of feeding back and making sure you understand when the lead really did come from them, because again, it's that's general to all agents that they do this. It's great fun working with them, but they are introducing you to as many people as possible, because actually at the end of the day, that's how they make their money one way or another. So you have to manage the reporting very closely. Sorry to interrupt you.
No, it's all very, very useful. Thank you. We've had I just wanted to bring up, actually, Liz spoke on a webinar we did last summer about agents and distributors, which I can circulate a link to afterwards because that was very useful on that particular topic. We've had a few questions as well around Brexit, kind of more general questions. We'll probably try and take those offline or defer those to our Brexit Q&A we're doing in a few weeks' time. But for now, we've got a couple more questions on this topic. One from Peter, and it's around kind of what currency you'd want to use and what currency a contract for a product, sorry, I'm not getting this right. Can you give guidance in terms of setting out which currency a contract would use? Leslie, do you want to speak to that, currency in terms and conditions?
Yeah, I mean, no, I wouldn't put currency in your terms and conditions, to be quite honest, because that's a very technical side, and sometimes you may want to be dealing in their local currency if that's appealing to that one contract or that one customer, and sometimes you want to be dealing in specific countries under sterling. It's really customer by customer how you decide to do that. Certainly I wouldn't put it in terms and conditions because it fluctuates too much. It's a sort of a side issue, really. It's for the final contract rather than for the terms of the offer that you're making. I hope you agree, Liz.
It's a tricky.
Hello?
Can you hear me? It's a tricky one currency, because obviously it fluctuates. The one thing that I know some businesses do, and we have done in the past as a business, is we've had a euro account and obviously sterling accounts, and we've kept money in our euro account, which has helped us not then incur all the costs of putting money to and from sterling, so you can save some costs.
But I think that it's not a question about how you manage it. I thought it was a question about whether you included it in your terms and conditions. And I think the technicalities of whether you're paying in the different currencies needs to be at a different level, which is much more in how you're managing the actual contract of delivery, rather than determining that in your terms and conditions.
Yes, what I have seen a lot of people ask is that they're always paid in sterling, but of course, unfortunately, that's not always possible.
Yeah.
Okay.
Is there anything else?
Yeah, I've got a couple more questions from a couple of Peters. One question is, if appropriate contacts can be found, is it sensible to get in-country advice for kind of legal issues like T&Cs and contracts? Liz, do you want to speak to that?
Sometimes it's vitally important to get local advice. For example, I had a client a few years ago who contracted using an English contract, and found themselves caught up in the Middle East with it being registered on a local registry as an agency agreement. And we had to unpick it by going to get local advice. That's less of a problem these days, but it can be an issue, and there are certain aspects, for example, that you may want to get local advice on. For example, how something operates, how a particular kind of limit of liability will operate in a different country. For example, the one that springs to mind immediately is what happens with a limit of liability in the USA, where they have quite different standards in relation to how liable a producer should be for something not working quite as it should. So there are instances where you will get local advice, but if you've got a specialist solicitor who deals with international trade, they should be able to highlight that to you before you actually use your terms and conditions.
Okay. And we've had an IP question actually come in. So Liz, this is right up your street. It's from another Peter, and he's asked, is there a simple way of protecting innovation in software when it cannot be easily protected as IP?
Contractually, generally, is how software is protected. And there are lots of technical ways that you can stop people from reverse engineering software in particular. The other thing too is depending on what the technical effect of the software is, in some instances it's possible to get patent protection on a piece of software if it has a particular technical effect. But the big one that we see time and time again is branding. Getting a trademark of your particular software product is the relatively cheap and easy way of making sure that they always ask for your product over something that does something very similar. So there are a number of ways of answering that question. I hope that covers it.
I think so. And yeah, if not, then get in touch with us after, Peter, and we can carry on that conversation. We've running a little bit low on T&C's questions, so we'll just put one quick Brexit question to you, Leslie. And that's from James, who's he as a company is looking to either hire an agent or buy software for import and exporting after Brexit, but he's saying there's very little information about that. So I think he's just asking for a bit of advice around import and export procedures after Brexit.
Okay.
Can you?
Yeah. Okay. Well, first things first. I'm not quite sure how large your company is, So, forgive me. If you're a small business, think very carefully before buying software, because it might mean that you get into a circumstance where you are spending like £15,000. That feels like a lot of money, and it might be better off just using a freight forwarder who would have a customs intermediary or a broker internal in-house. The second thing I would say, please take advantage of the training day that we have, which is a customs procedures and documentation day. If you click on our training courses, there's a customs pathway. This is the entry level, and you can get a PwC HMRC grant to actually attend it. So it's only going to cost you a minimal amount of money. You get up to 70% discount on that, and it will help you understand what your implications are, and probably, hopefully, give you a choice as to whether you should be buying software or appointing an agent. Doing it yourself is quite complex, and if you're a larger organisation, that's fine. The only thing you'd have to do is set yourself up to be able to have a bond or a guarantee with Customs and Excise, which would actually be an impact on your banking facility. And it depends on whether you want to have that or whether you'd sooner use a customs broker who would do that on your behalf. There's quite a lot of issues. In fact, actually, I'm beginning to realise we need to do perhaps a webinar on this in its own right. But we are working on a lot of different areas. These HMRC programs of activity, actually how to complete a C88 form, which is the form that you need to complete. And the information, so you actually give the right information to your freight forwarder, would make a huge difference as well. So, watch out for what we're advertising. Look at the customs page. Look at the fact that we've got this, the grants that are available for you to do that, and do it soon, because the grants will run out. They're only talking about doing them until the end of March. Obviously, we know that people will still need that, and we're also developing some training days that are very, very specific to Chief and completing the documentation. So, keep your eyes open. There's a lot going on in this space, but do get involved, because actually, buying software isn't the only answer. You still got to work out how you're going to find the information that you need for that too. So it's quite big. I hope that helps.
Absolutely, thank you, Leslie. And as mentioned, we will be doing a Brexit Q&A soon as well, and we can maybe try and cover a few of those points in that session as well as another one. On that note, I think we're going to wrap up. Thank you once again to Leslie and Liz for your presentations and answers. I will make sure to include links with more information about the new templates being provided by the IUE, and some of the support provided by Virtuoso Legal in the aftermath to this webinar, so keep your eyes peeled for that. But yeah, thank you, Leslie and Liz. If you need more detailed information and support in regards to preparing for Brexit, as mentioned, the Institute of Exports and International Trade is continuing to run several training courses around Brexit and export processes in general. Among these are the post-Brexit planning workshop and Brexit health check services we provide. And as Leslie mentioned, you can apply for government funding for many of our customs-related courses. This funding is designed to support businesses who are or will be required to make customs declarations in the near future, which will be a big requirement in the event of a no-deal Brexit. Links to all of these services and courses can be found at export.org.uk/training. And again, I will circulate all the links in the aftermath to this webinar. We've also got World Trade Summits coming up in Southampton and Manchester over the next few weeks. These are great opportunities to network and learn from fellow exporters and trade specialists in the regions, and you can find sign-up details for all of these at export.org.uk/events. The deadline for our 10th Export Action Plan competition passed last Friday, but we will be launching a new spring competition very shortly. The competitions are a great opportunity for SMEs to create a coherent plan of action for their international growth using our online planning tool. And the winning plan will be given £3,000 cash towards implementing their plan. Information about the competition can be found on the website, and we will definitely encourage you to enter and complete the tool. Our next webinar is a Q&A session about Brexit on March the 7th, which I'm sure will be a very popular session. After that, we're tackling currency on March 20th with BB Financial Services. Sign-up details for those webinars can be found at opentechexport.com/webinars. And again, I'll circulate registration details for those webinars after this one. As always, please do take our exit survey to let us know what you thought of today's webinar and to give us any suggestions for improvements or future topics. But for now, goodbye.